Your lease almost certainly contains at least one clause that is completely illegal, not contested, not legally gray, void, the way a contract to sell yourself into slavery would be void. And in Wisconsin, if your landlord inserted even one of what state law calls the deadly sins, a specific list of prohibited clauses, you can nullify the entire lease at your option. Walk out. No back rent, no penalty. The landlord loses all contractual recourse. Most tenants never find out this option exists. Here's what makes this genuinely uncomfortable. Landlords who insert these clauses often know they're unenforceable, but an unenforceable clause a tenant believes is real works just as well as a legal one, until someone pushes back. The legal foundation of what we're about to cover comes from a 1970 federal case, Javans versus First National Realty Corporation. The U.S. Court of Appeals for the District of Columbia dismantled centuries of property law in a single ruling. Before that decision, a residential lease was treated like a deed, a pure conveyance of land. Your obligation to pay rent was absolute. The roof could collapse, the building could flood, vermin could colonize every cabinet. Court said you still owed the money. The Javans court rejected that entirely. A residential lease, it held, is a consumer contract, an agreement with mutually dependent terms in which public policy overrides the fine print. What a landlord writes into a lease and what a landlord can legally enforce are two very different lists. Here are 7 of the biggest gaps between those lists, and what you can do about each one. Start with the clause that catches tenants most often. If your lease has language declaring the security deposit non-refundable, that clause is void. Full stop. Security deposits are refundable by default under statutory law nationwide. A landlord can retain them only for unpaid rent or actual physical damage you caused. Not general wear, not cosmetic age, actual damage. This distinction, normal wear and tear versus compensable damage, is where most deposit disputes collapse. And here's the part landlords count on you not knowing. Courts use HUD life expectancy guidelines for property components to determine what a landlord can legally charge. Under those guidelines, carpet has a standard life expectancy of 5 years. If a carpet was 3 years old when you moved in, it had 2 years of useful life remaining. You live there for 1 year. When you leave, it has 1 year left. Even if you destroyed it entirely and a replacement costs $2,000, the landlord is legally restricted to deducting 20% of that cost. $400. Not $2,000. $400. That formula is not optional. It exists specifically to prevent landlords from using departing tenants to finance full property renovations. In Massachusetts, under the precedent set in Miller versus Berman in 1983, courts held landlords liable for treble damages, triple the withheld amount, even when the landlord believed they were acting in good faith. The procedural error alone was enough. Intent didn't matter. Next, landlord entry. Many leases contain language granting the landlord the right to enter the unit at any time or whenever necessary. The first formulation is illegal. The second depends entirely on what the law says, not what the landlord decides. California requires 24 hours of written notice for standard entries and 48 hours for pre-move-out inspections. Those are the statutory minimums under California Civil Code Section 1954. Florida requires 12 hours for repair visits, between the hours of 7:30 a.m. and 8 p.m. only. New York follows a common law standard, typically interpreted as 24 hours. Texas has no statutory floor, but courts apply the implied covenant of quiet enjoyment, a legal doctrine establishing that a tenant has the right to occupy their home without interference from the landlord. A clause saying landlord may enter at any time isn't just unenforceable. Repeated entries under it, Even entries where notice was technically given can establish a pattern of harassment. California allows civil penalties of up to $1,000 per violation, plus actual damages, plus punitive damages. The courts have been consistent. The moment you sign a lease, you hold exclusive possession of that unit. The landlord surrendered that access at closing. But there's a category of lease violation that most tenants have never considered. And it surfaces every time a landlord wants a tenant gone without going through the legal process to do it. Guest restrictions often look like housekeeping rules. They're not. Landlords can set reasonable occupancy limits to prevent unauthorized permanent residence. What they cannot do is issue absolute guest bans or curfews. Those violate the tenant's right to exclusive possession and quiet enjoyment. Guest restrictions that disproportionately affect children also trigger federal fair housing liability. Under the Fair Housing Act, it is illegal to discriminate in the terms of a rental based on familial status, the legal category that protects households with children under 18. In 2017, a Florida federal court reviewed a homeowner association curfew, stating that after dark, all children should be in their homes. The court struck it down as facially discriminatory on its face under the FHA. The curfew sounded neutral. It wasn't. Pet clauses require a separate legal analysis entirely. If you have a documented disability, mental, emotional, or physical, and a licensed healthcare provider has confirmed that an animal helps manage it, your landlord cannot enforce a no pets clause against you. The Fair Housing Act, Section 504 of the Rehabilitation Act, and the Americans with Disabilities Act classify service animals and emotional support animals not as pets, but as assistive medical devices. You wouldn't pay a deposit for a wheelchair. Federal law says you cannot be charged a deposit for an ESA either. Breed restrictions that would apply to ordinary pets don't apply. The landlord can deny the accommodation only by documenting that the specific animal poses a direct, measurable threat to other safety. A legal bar that is, in practice, very difficult to clear. Now, here's the part of the law that tends to stop people mid-sentence when they hear it for the first time. Self-help evictions. The landlord changes your locks, removes your doors or windows, cuts off your water, electricity, gas, or heat, takes your belongings. Every one of these actions is illegal in all 50 states. Not most states, all of them. The only legal path to remove a tenant is a formal judicial proceeding, what's called an unlawful detainer action, resulting in a court-issued writ of possession, executed by law enforcement. That's the complete list. No shortcuts, no exceptions. What happens to landlords who try anyway? Under California Civil Code Section 789.3, landlords face mandatory statutory damages of at least $100 per day for each day the violation continues. That amount is roughly equivalent to what an average Californian earns in 2 hours, and it runs every 24 hours until the tenant is restored, on top of actual damages, on top of attorney fees. And under California Penal Code Section 418, a self-help eviction is a criminal misdemeanor, up to 6 months in county jail. In Texas, an illegally locked out tenant can recover 1 month's rent plus $1,000, plus actual damages, plus an emergency court order for immediate re-entry. In New York, under the Housing Stability and Tenant Protection Act of 2019, an extrajudicial eviction attempt is a Class A criminal misdemeanor. Civil penalties range from $1,000 to $10,000 per violation, plus triple damages for the displaced tenant. A landlord owed 6 months of unpaid rent has exactly as much right to change your locks as a landlord acting on pure spite, which is to say, none at all. Before we get to what courts say about the legal remedies here, there's one more category of illegal clause, and it's the quietest one. These are what legal scholars sometimes call sneaked provisions. Language inserted into boilerplate leases that sounds authoritative and looks official, but is void the moment a court reads it. A clause stating the tenant accepts the property as is and waives their right to repairs? Void. The implied warranty of habitability, the legal obligation built into every residential lease by operation of law that the landlord will maintain the unit in livable condition, cannot be contractually waived. The clause is meaningless from the moment it's printed. A clause requiring the tenant to pay the landlord's attorney fees in any dispute, regardless of outcome? Courts in most states apply mutual fee-shifting doctrines. The prevailing party recovers fees. The lease provision is overridden. A rent acceleration clause, language declaring that if a tenant violates any lease rule, all remaining rent for the entire term becomes immediately due, unenforceable as an illegal punitive penalty. Courts have consistently refused to treat them as legitimate liquidated damages. And then there's the clause that generated some interesting reactions in legal academia when it started appearing in residential leases. Language threatening eviction or other penalties if the tenant contacts law enforcement, the fire department, or emergency services. Those clauses are void everywhere as a direct threat to public safety. American landlord-tenant law has produced some impressively creative paperwork. That observation stands without further elaboration. So, where does this leave tenants who've encountered these clauses? The courts have answered that question consistently for 50 years. Void clauses are void. The landlord cannot enforce them. If the deposit was illegally withheld, you can sue for it back. In Massachusetts, you might recover triple the amount. If your locks were changed without a court order, you can sue for that too. In California, those damages start accumulating at $100 a day. Automatically, if entry occurred without proper notice, quiet enjoyment was breached. In Wisconsin, if any one of the prohibited clauses appears in the lease at all, the entire agreement can be voided at your option. The landlord loses everything, not because of what they did, because of what they wrote. The landlord drafted a document that looked like it gave them power. The court read it and found something else. A list of promises the law had already decided they couldn't keep. Here's what this means if you're renting right now. Pull out your lease and look for 5 specific things. Any clause declaring the deposit non-refundable, language granting the landlord unrestricted entry, absolute guest or visitor bans, rent acceleration clause stating all rent becomes immediately due for any violation, and any language waiving your right to contact emergency services. If you find any of these, they are not enforceable, but knowing they exist before a dispute is considerably better than discovering them after one. If you're entering a new lease, the deposit calculation alone is worth 30 minutes of your time before you sign. Document the condition of everything at move-in. Date stamp photographs of every room, every surface, every appliance, every pre-existing mark. Send them to the landlord via email the day you move in. That email timestamp is your baseline in any dispute. It is, functionally, the most important thing you do on day one. If a landlord has already taken an action that matches what we've described, a lockout, a utility shutoff, a deposit that hasn't returned within your state's statutory deadline, small claims court was designed for exactly this situation. In most jurisdictions, you don't need an attorney. You need the lease, the photographs, the certified mail receipts, and the knowledge that the law was almost certainly on your side before the dispute started. Something worth putting in the comments. Should landlords be legally required to attach a plain language summary of unenforceable clauses to every residential lease before a tenant signs? Other consumer contracts carry mandatory disclosure requirements. The question is whether residential leases should too. Subscribe if you want to keep seeing this kind of analysis. The next video covers something equally counterintuitive, the NDA that a company used to protect confidential information and that accidentally made everything it was supposed to hide legally public. That case has no good outcome for anyone who wrote the contract.